The level of trust and confidence in the judiciary of Ukraine has never been regarded as high. Especially sharply this problem emerged at the time of President Viktor Yanukovych. Right after the Revolution of Dignity, the Ukrainian society demanded to lustrate the dishonest judges. Finally, the time has come for judicial reform. In February 2015, the new law of Ukraine on ensuring the right to a fair trial has been adopted. According to this law, all judges are obligated to pass the qualification assessment. Now there are about 8,000 judges in the country, and the High Qualification Commission of Judges of Ukraine is entrusted to conduct out such an assessment regarding them all.
The procedure of the qualification assessment in Ukraine is unique among all countries in the world. There are almost 8,000 judges in Ukraine, and several hundred of them have already passed the assessment before the High Qualification Commission of Judges of Ukraine. The commission operates in two chambers, and the board consists of 14 members. 10 of them are judges or retired judges, and 4 are advocates and professors of law. First results were impressive not only for the commission, but for the society as well. About 20% of judges had resigned before the beginning of the assessment procedure. Some of them tried to avoid the assessment, and some of them failed to attend it for the various reasons. It shows that judges have the option to decide independently whether to quit the judicial career or not. A small number of judges failed to pass the assessment, but more than 50% successfully passed it and will continue to administer justice.
The initial qualification assessment is going smoothly as planned because we have been preparing thoroughly for it. The public judges and media have agreed that there is nothing to be scared about the procedure. It is only a standard assessment. Surely, for us it may be not an ordinary procedure, but a unique one. However, it has been deliberated by all public authorities and members of the High Qualification Commission of Judges of Ukraine. All internal procedures of the initial qualification assessment have been developed and thought out with precaution.
The development and approval of all documents was carried out by the Commission with an active support of the European Union, Council of Europe, Organization for Security and Cooperation in Europe, Office for Democratic Institutions and Human Rights, and the government of the United States of America. Within their projects, the experienced and recognized experts provided the Commission with the proposals and opinions regarding the assessment procedure, taking into consideration all international standards.
Immediately after the Revolution of Dignity, our cooperation with the High Qualification Commission of Judges of Ukraine is very fruitful, and we see that the management of the Commission and its members are very motivated, and in my opinion, this is very good perspective. As for the support of our project to all actions of the Commission, we were engaged in the development of the regulations concerning the assessment of judges. Our experts from other European Union countries assisted the High Qualification Commission of Judges of Ukraine during the development of such regulations.
We've been able to build up very good relationships with many important institutions, and one of them is precisely the High Qualification Commission of Ukraine, which is working in an area that is key for the Council of Europe, namely the role and the status and the position of judges. And this is something we're interested in. Of course, it's important for the protection of the rights of the people in Ukraine and for people to have access to justice. So we have an excellent partnership with the High Qualification Commission.
The law on ensuring a fair trial, adopted by the Rada in 2015, marked a significant step forward on judicial reform. The High Qualifications Commission of Judges launched the process of evaluation of qualifications of those judges who are being considered for a lifetime appointment, as required by the new law. I am very proud that the United States, through USAID, has been able to assist in this process.
The initial qualification assessment consists of two parts, an exam and an interview based on the results of the judicial dossier verification.
The exam has two phases. The first phase is the written anonymous testing concerning legal positions of the Supreme Court of Ukraine and also the opinion contained in the judgment of the European Court of Human Rights. The second phase relates to executing of a practical task, which allows checking the level of knowledge and professional skills of a judge, which let him make judgments and and lead respective trials. The particular situational exercise must be discussed with the members of the Commission. A judge who has passed the exam must undergo the second phase of the interview, based on the results of the verification of its judicial dossier. What is the nature of a judicial dossier? It is a track record which contains and reflects all aspects of the professional activity of a judge, including compliance with the norms of ethical behavior along with the anti-corruption criteria. Newly established National Anti-Corruption Agency of Ukraine actively cooperates with the Commission and provides actual information concerning possible corruption risks in due course. When the verification of a judicial dossier is complete, the Commission takes into account provided information and assesses excellence, efficiency and professionalism of a particular judge and takes the final decision on confirmation or non-confirmation of the possibility of a judge to administer justice in the appropriate court.
The High Qualification Commission of Judges of Ukraine has started the initial qualification assessment in February 2016. The first group of judges who have been assessed were the judges applying for the lifetime appointment. After, the Commission started to assess the representatives of appeal courts. How the assessment process of judges is carried out, what questions judges are being asked by the members of the Commission, what difficulties judges are facing in the process, and who, on the contrary, demonstrates the excellent knowledge, together with the absence of corruption sites in their activities. Let's take a look.
Initially you told that there weren't enough evidence, so it is clear that your actions are procedural and how you litigate what you are doing. You have received declaration, case material. Please indicate your further actions.
Thanks for your question. I consider this is not a reason for leaving the claim to the court, since it does not provide evidence and it's not a reason for leaving the claim without movement. I would assign the case for preliminary hearing and suggest the parties, according to the Article 10 of the Criminal Procedure Code, provide relevant evidence. For example, in this case, I would request, as I already stated, work rule. I would request other documents and offered to the other parties since the court is a passive participant of the process, in accordance with the rules of Civil Procedure Code and is not authorized to collect evidences.
You have a new car. The car is newly made. It was bought in 2013 and the year of production is also 2013. This car is expensive, really expensive. We won't name the price. And you are saying, well, I don't know, my husband is unemployed. Well, I don't know where he got the money from. His parents are retirees.
Well, his parents used to work in the past.
They were not businessmen?
No, they were not. No, they do not have any business activities.
You should understand that due to the situation that currently takes place in the country, our duty is to ask you these questions.
I understand.
And to find out everything. Well, we don't have a clear explanation from you. If you have a simple and logical answer, tell us. If you don't, we will go on.
I can't explain. Maybe my husband might have some savings. Maybe his parents provided him with money.
Where did he work before his unemployment?
He is not working right now, and he didn't work prior.
He never worked at all?
No, he didn't.
And why Mr. Shokin applied to the European Court of Human Rights, and what were the grounds?
Mr. Shokin applied with a statement on unfairness of the trial and failure to follow the legality principle during interference by the public authorities into his operations. When the European Court was considering the issue, it did set out a disproportion and unlawfulness of such interference and concluded the violation of the applicant's right guaranteed by the Article 1 of the Protocol number 1. It also referred to the norm 4.4.1 of the law, number 2181, regarding the conflict of interests. According to it, the doubt shall be interpreted in favor of the taxpayer. This rule confirms the legitimacy of the applicant's position. The European Court found strange the disregard of the Article 7, paragraph 3, when this rule shall to be applied.
Paragraph 3 of which act?
Of the Decree number 1392 on income tax. The instruction had also the same title, but later on it was renamed into Instruction on Taxation of Entrepreneurs.
And why had it applied directly to the European Court?
Because all courts of all levels denied him twice in cancellation of tax notices and decisions on the increase in the applicant's income tax liability.
And how were these tax calculated?
It was calculated under the progressive rate, and the applicant insisted that this article of the decree envisages clear 20% rate under which he had calculated his income tax.
What is your PhD thesis topic?
Administrative responsibility of physical and legal entities in the European Union.
When did you write it?
I wrote it in the state University. Sorry, I will answer.
It's okay.
State University of Home Affairs in Dnipropetrovsk City.
Who was your PhD thesis advisor?
Korneev, Andrei.
Don't you remember the middle name?
I don't remember it.
I see. It's not good. You must know it. Tell me, please, what is your English level?
Fluent. My second language is French, and I know it well.
Okay, then tell me, what is acquis communautaire?
Say it again.
Acquis communautaire. You wrote your PhD thesis directly on the topic. Acquis communautaire. 2 words in French, but it is an established term within the territory of the Union you wrote about.
In the European Union?
Right, in the European Union, and it is mentioned about 40 times in the association agreement with the European Union, and it directly relates to judiciary.
According to the current rules of the Economic Procedural Code of Ukraine, at the stage of the appeal proceedings, the court shall not accept a waiver of a claim and to approve this request for a waiver. However, there are proposals to amend the respective code on this matter. The working group subject to developing these proposals suggests considering the decision in this part as void by analogy with administrative legal proceedings. But for now, this position is not reflected in the Economic Procedural Code, so we shall not accept request for a waiver of a claim.
In your declaration for 2014, you have indicated securities which belong to you with nominal value 28.4, contributions to statutory funds 30.8. You're indicating not thousands but millions. Please provide us with the circumstances of the acquisitions of the ownership rights. Please tell us.
All corporate rights which were announced, they were acquired before the position of a judge. They were acquired starting from 1995. When I was 15, my mother, who was engaged in business activity, when some companies were in bankruptcy, she bought such shares, corporate rights. Besides, she gave me money in order to purchase such corporate rights. Starting from 1995, statutory funds of these companies was increased. How would you define the notion reasonable term? Tell in your own words, please.
In my own words, it is in words of the Code of Administrative Legal Proceedings of Ukraine. It means the shortest term during which the case shall be heard overall. But again, it depends on many factors, on parties to a case and on complexity of the particular case. Sometimes it is better to infringe terms of the case hearing, but to collect all the necessary documents and to call properly all parties to a case.
As of 1st of June 2016, the assessment process attended 306 judges. 20 of them could not confirm the possibility to administer a justice, were temporarily suspended from work and directed for study to the National School of Judges of Ukraine. After retraining, they're supposed to pass a reassessment. In case if they fail again, these judges will be recommended for a further dismissal. Regarding the assessment of 52 judges, the process of assessment was adjourned.
The High Qualification Commission of Judges of Ukraine started the qualification assessment of judges in February 2016. At the beginning, judges had extremely bad knowledge of the case law of the European Court of Human Rights. More than that, they couldn't explain their incomes and assets in fiscal declarations. In May 2016, judges started to provide more substantial answers regarding the European Court of Human Rights case law. Currently, they are much better prepared with their responses, in particular concerning their financial documents. Judges became more responsible towards their decisions, which were amended or cancelled by a higher instance court. Such tendencies, from one hand, indicate that the goal we set is not targeted at the punishment, but to identify the best judges from the profession. Judges who will confirm the ability to administer justice in the appropriate court, and from the other hand, to recommend judges who do not meet the requirements to leave the bench.
I will probably remember everything that happened on the day of the assessment, but it should be noted that completing these practical tasks is very useful for us, judges. It would be worthwhile to pass such tests in the National School of Judges of Ukraine even annually, in order to understand our current professional level and to upgrade our qualification if needed.
The initial qualification assessment is organized properly. All information is provided timely and easy to understand. The judges are assessed objectively. In addition, the judges who are subject to the qualification assessment have noticed polite and friendly attitude of the Commission members. Till now, any negative remarks from me and my colleagues regarding the process of the initial qualification assessment have not been noticed.
For the media representatives and other stakeholders, there was allotted a special room where broadcasting of the assessment procedure was organized. We had the opportunity to see how exactly the assessment was held, evaluate the professional skills of judges, and hear the answers to the most topical questions that arose in the society and were asked by the Commission members during the interview stage.
The adoption of the new law on the judiciary and the status of judges in the new edition, as well as the amendments to the Constitution of Ukraine in the part of judiciary taking place in the early June 2016, became the next step of the judicial reform of Ukraine.
The amendments to the Constitution adopted by the Parliament of Ukraine on the 2nd June 2016 have forced the Commission to be prepared for the vitally important event. It is the announcement of the complex competitive selection process to the Supreme Court of Ukraine. I would like to bring your attention to amendments in the Constitution that will eliminate high specialized courts and reform the structure of the Supreme Court of Ukraine. The new Supreme Court of Ukraine will be created and it will consist of approximately 200 judges. Not only judges would have an opportunity to apply to the Supreme Court of Ukraine, but also advocates and other representatives of legal professions, having at least 10 years of experience in representing clients' interests in the courts, as well as legal scholars. This complex competitive selection will also take place through the qualification assessment. This will provide an opportunity to evaluate professional skills and moral qualities of judges who will apply to the Supreme Court of Ukraine together with other candidates for the competition.
The judicial reform is the obligation of Ukraine before the European Union in the frameworks of mutual association agreement. The amendments to the Constitution of Ukraine are essential for the entire judicial system, and they're supposed to be the basis stone in ensuring people's right to a fair trial.